Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy! The following are the concurring reasons of Appeal Justice Doherty. I have read the reasons of my colleague Appeal Justice Bonotto. I agree entirely with her analysis of the fitness of the sentence and her proposed disposition of the appeal. I would add only that, absent the impressive array of mitigating factors which included a guilty plea, the small loss suffered by the CRA, full restitution, the respondent's youth, and his first offender status, a significantly longer sentence would have been necessary. I part company with my colleague, however, on the constitutional question. In my view, this court should address the merits of the constitutional argument. I agree with the trial judge that the 2-year mandatory minimum in Section 380 sub 1.1 does amount to cruel and unusual punishment, and that the section should be declared of no force or effect. The Section 12 analysis. The Supreme Court has repeatedly stressed that the requirement that the sentence be grossly disproportionate sets a high constitutional bar. Sentences that are merely excessive or disproportionate so as to warrant appellate intervention on a sentence appeal do not necessarily rise to the level of cruel and unusual punishment. For example, the trial judge correctly acknowledged that an 18-month sentence, the sentence he regarded as fit for the respondent, would not render the 2-year mandatory minimum sentence grossly disproportionate as applied to the respondent. In addition to reaffirming the two-step approach to the analysis of a Section 12 claim, NER reiterates that the analysis must be applied first to the offender, and, if the mandatory minimum as applied to the offender does not offend Section 12, to other putative offenders, referred to as reasonable hypotheticals, who might reasonably be caught by the provision. Constitutional review that extends beyond the circumstances of the specific case and the specific offender is not unique to Section 12. A person who is subject to a law can challenge the constitutionality of that law, even if the law does not infringe that person's constitutional rights. Chief Justice McLaughlin in NER offers an eloquent explanation for the need to go beyond the circumstances of the individual case when assessing the constitutionality of a law. Quote, not only is looking at the law's impact on persons whom it is reasonably foreseeable the law may catch workable, it is essential to effective constitutional review. Refusing to consider reasonably foreseeable impacts of an impugned law would dramatically curtail the reach of the Charter and the ability of the courts to discharge their duty to scrutinize the constitutionality of legislation and maintain the integrity of the constitutional order. The protection of individuals' rights demands constitutional review that looks not only to the situation of the offender before the court, but beyond that to the reasonably foreseeable reach of the law. Testing the law against reasonably foreseeable applications will prevent people from suffering cruel and unusual punishment in the interim until the mandatory minimum is found to be unconstitutional in a particular case. Refusing to consider an impugned law's impact on third parties would also undermine the prospect of bringing certainty to the constitutionality of legislation, condemning constitutional jurisprudence to a wilderness of single instances. Citizens, the police, and government are entitled, and indeed obliged, to know what the criminal law is and whether it is constitutional. Looking at whether the mandatory minimum has an unconstitutional impact on others avoids the chilling effect of unconstitutional laws remaining in the statute books." End quote. With respect to the contrary view, I do not accept an approach that limits a Section 12 claim to the circumstances of the specific offender and any reasonable hypotheticals advanced by the parties or considered by the trial judge. While procedural fairness demands that the parties have a full opportunity to address any reasonable hypothetical on which the outcome of the constitutional challenge may turn, this court is obliged to consider any hypothetical it views as a reasonably foreseeable application of the mandatory minimum. The court cannot decline to consider reasonable hypotheticals on the basis that those same hypotheticals can be raised and considered in some future proceeding. The Section 12 analysis in this case focuses on the application of the mandatory minimum to reasonable hypotheticals. The respondent does not argue that a sentence of 2 years would be grossly disproportionate in the circumstances of his case. I will return to the reasonable hypothetical inquiry later in my reasons. Before doing so, however, it is necessary to address the elements of the crime of fraud and the relevance of the value of the subject matter of the fraud to the gravity of the offense and the moral culpability of the offender. The elements of fraud. Fraud, as described in Section 380 of the Code, consists of voluntarily performing an act that is in the nature of a deceit, falsehood, or other fraudulent means. The prohibited act must result in actual pecuniary loss to the victim, or it must place the victim's pecuniary interest at risk. The actus reus of the crime of fraud is captured by the phrase dishonest detriment. The fault or mens rea component of the crime of fraud has 2 parts. The Crown must prove subjective knowledge of the prohibited act. Thus, in cases like this one, involving an allegation of false representation, the Crown must prove that the respondent knew that the representation in the forms to the effect that the identified corporations were redirecting the deposits to a different account was false. In addition to knowledge of the falsity of representation, the Crown had to prove that the respondent knew that in doing the prohibited act, he could cause actual pecuniary loss to the CRA or could put the CRA's pecuniary interest at risk. In other words, the Crown had to prove that the respondent knew that, by falsely redirecting the refunds into bank accounts he controlled, the CRA could lose those funds or, at a minimum, be put at risk of losing those funds. The Crown did not have to prove an intention to cause loss or risk of loss. It was sufficient if the Crown proved that the respondent was reckless as to that consequence. There is no doubt that the crime of fraud, first introduced into the Code in 1954, captures a very broad range of activity and is designed to encompass the entire panoply of dishonest commercial dealings. Fraud, as defined in Section 380, creates a broad, honesty-based criminal offense freed from the limitations and qualifications that had grown up over centuries around common law-based property crimes, such as obtaining property by false pretenses. The courts have given the crime of fraud the very broad reading intended by the language of the section. The long reach of the crime of fraud is important to the Section 12 analysis. Mandatory minimums that apply to offenses that can be committed in many ways, in many different circumstances, and by a wide range of people, are constitutionally vulnerable under Section 12 because, by virtue of their broad scope, they run the very real risk of capturing offenders for whom the mandatory minimum will be grossly disproportionate punishment. If the 2-year mandatory minimum applied to all crimes of fraud over $5,000, it could not survive Section 12 scrutiny. First offenders who plead guilty to fraud over $5,000 quite often do not go to jail at all, much less to the penitentiary for 2 years. It takes no imagination to envision reasonably foreseeable circumstances in which a sentence of 2 years for fraud over $5,000 would constitute a grossly disproportionate sentence. One only need to read the reported cases. The reach of the mandatory minimum. The mandatory minimum in issue does not apply to all frauds over $5,000. Subsection 380 sub 1.1 provides that when a person is convicted of fraud, the court shall impose a minimum punishment of imprisonment for a term of 2 years if the total value of the subject matter of the offense exceeds $1 million. The value of the subject matter of the offense refers to the amount of the loss or risk of loss suffered by the victim. The question becomes, does limiting the mandatory minimum to frauds in which the loss or risk of loss is over $1 million adequately distinguish those frauds for which 2-year sentences would not be grossly disproportionate from those frauds which 2 years would be grossly disproportionate? Put somewhat differently, is the fact that the value of the subject matter of the fraud exceeds $1 million a sufficiently aggravating factor on sentence that it overrides mitigating factors that could arise in reasonably foreseeable situations, to the extent that a 2-year sentence in reasonably foreseeable cases of fraud over $1 million will never be grossly disproportionate. In examining proportionality, one looks to the relationship between the mandatory minimum and the penalty that would be imposed, using the generally applicable principles of sentencing. Those principles focus on the gravity of the offense, the harm caused by the offense, and the blameworthiness of the offender's conduct. if the sentence commanded by the mandatory minimum is grossly disproportionate to the sentence that would be imposed under the generally applicable principles of sentencing, the mandatory minimum violates Section 12. The value of the subject matter of the fraud has always been an important consideration in determining the gravity of the crime of fraud. Not only does Section 380 distinguish between the two levels of fraud based on the value of the subject matter of the fraud, above or below $5,000, Section 380 sub 1(1)(a) specifically provides that the magnitude of a fraud must be treated as an aggravating circumstance on sentence. The amount of the loss or risk of loss speaks directly to the magnitude of the fraud. By tying the mandatory minimum penalty to frauds that involve a very substantial loss or risk of loss, Parliament has connected the mandatory minimum to a factor that clearly identifies potentially serious frauds. The value of the loss or risk of loss can also reflect the harm caused by the offense. In cases in which the victim suffers an actual loss, there is a direct and strong correlation between the value of the loss and the harm caused. The greater the loss, the greater the harm. That connection is weaker when there is no actual loss, but rather a risk of loss. The level of risk sufficient to satisfy the detriment component of the actus reus of fraud runs along a continuum. Sometimes the risk of actual pecuniary loss may be small. In some reasonably foreseeable circumstances, the amount of the fraud will be over $1 million, but the actual risk of loss will be low, and there will be no actual loss. In those cases, the harm flowing from the fraud will be minimal. The third factor relevant to proportionality in sentencing, the blameworthiness of the offender, may or may not have some correlation to the value of the subject matter of the fraud. In most frauds, the offender will know, at least in general terms, the amount of the victim's loss or risk of loss. The offender's gain is often a reflection of the victim's loss. In those typical cases, the offender's understanding that the subject matter of the fraud involves a large amount of money increases the blameworthiness of the conduct. There are, however, situations in which the value of the fraud does not contribute to the blameworthiness of the offender's conduct. 2 points should be made. First, fraud does not require an intention to cause loss or risk of loss to anyone. Recklessness will suffice. Some fraudsters firmly believe that everyone will be better off financially after the fraud is perpetrated. Second, and this is particularly significant in assessing blameworthiness, the amount of the fraud plays no role in determining liability for the offense. The Crown is not required to prove that an accused was aware of or even turned her mind to the amount of the fraud or the amount put at risk by the fraud. Consequently, the value of the subject matter of the fraud will, in some cases, say nothing about the blameworthiness of the offender's conduct. Indeed, on the agreed facts of this case, when the respondent filed the first batch of false RC 366 forms, he did not turn his mind to the amount of any deposits that might be redirected into his account. The reasonable hypothetical. Nur, at paragraph 62, describes reasonable hypotheticals as grounded in judicial experience and common sense. Reasonable hypotheticals do not include far-fetched examples that marshal every conceivable mitigating factor in a combination that will never realistically arise in the real world. Reasonable hypotheticals do, however, include not only circumstances that are likely to arise in the general application of the law, but also situations that may reasonably arise. Reasonable hypotheticals include personal characteristics of an offender, such as age or the absence of a criminal record, but again, not constellations of mitigating personal circumstances that defy human experience. The trial judge referred to 3 hypotheticals. My colleague has examined each of them. I agree with much of what she says. The first 2 hypotheticals are cluttered with details that tend to render the criminality of the conduct questionable. Reasonable hypotheticals must present facts that clearly establish liability for the offense. I also agree with my colleague that on the limited facts offered by the trial judge in the 3rd hypothetical, there is no basis to conclude that the mandatory minimum would be grossly disproportionate. I test the constitutionality of the mandatory minimum against a reasonable hypothetical that is a variation of the trial judge's 2nd hypothetical. This variation is very close to the agreed facts in this case, as they apply to the first batch of fraudulent RC 366 forms filed by the respondent in August 2013. This hypothetical was put to counsel in the course of oral argument. Assume A comes across the CRA website and the instructions about direct deposit banking. Although it seems too easy to be true, A decides to try to make some quick money by sending in one fraudulent RC-366 form, directing payment of certain tax rebates owed to a corporation into his account. He picks a company at random and sends in a fraudulent form. A never turns his mind to the amount of any payment he might receive from the CRA. In fact, he assumes that the CRA must have some way of checking the information in the forms, and he doubts that his scheme will be successful. A few days later, A is shocked to see that the CRA has deposited $3 million into his bank account. At the same time, he learns that his bank has frozen the account pending inquiries. A quickly assesses the situation. He realizes, given the very large amount that has been deposited into his account, that he is potentially in very serious trouble. A also appreciates that, because of the actions of the bank, he will not be able to get any of the money out of the account, and the CRA will learn of his deception very soon. A decides to make the best of a bad situation. He goes to his bank and tells him that the money does not belong in his account and asks that they return it to the CRA. A also notifies the CRA. The police become involved. A pleads guilty to fraud and cooperates fully. He is a young first offender with strong community support and solid prospects. On the facts of the hypothetical, there is no question that A is guilty of defrauding the CRA. He knowingly made false representations, redirecting public funds from taxpayers to whom they were owed to his account. He knew he was creating the risk that the CRA would suffer a pecuniary loss, even though he never turned his mind to the amount of that potential loss, and certainly did not anticipate anything like the amount that was deposited into his account. The CRA suffered no loss, and because of banking policies, any risk of pecuniary loss as a consequence of A's actions was minimal. In terms of A's blameworthiness, the conduct was deliberate and dishonest under any definition. However, it was, to a large extent, spontaneous and opportunistic. This was not a carefully planned out or sophisticated scheme. It was in fact bound to fail when A realized that inevitability and the amount of money involved. He moved quickly to acknowledge his wrong and take responsibility for it. In my view, a trial judge sentencing A might reasonably conclude that, despite the many mitigating factors, the value of the subject matter of the fraud, combined with the public nature of the funds, required a denunciatory sentence that included a jail sentence in the range of 6 to 12 months. Other sentencing judges might conclude that a jail term was unnecessary. However, a sentence of 2 years in the penitentiary is far beyond what is reasonably necessary to deliver that denunciatory message. A sentence of 2 years also grossly overstates the blameworthiness of A's conduct and the loss caused by his conduct. A jail sentence which is at least double the sentence at the outer limits of proportionality is properly characterized as grossly disproportionate. Mandatory minimum sentences alter the sentencing dynamic. That dynamic generally relies on sentencing judges to balance all relevant factors and impose a sentence within the very broad range set out by Parliament that is tailored to the specific circumstances of the offense and the offender. Subject to constitutional restraints, Parliament is entitled to dictate sentencing policy by, for example, imposing mandatory minimums that favor general deterrence and denunciation over the individualization of the sentence. Section 12 of the Charter, however, limits Parliament's authority to sacrifice other sentencing principles in the name of deterrence and denunciation. Deterrence and denunciation cannot be achieved by the imposition of grossly disproportionate sentences. That strategy is constitutionally unacceptable. In most cases, and this is certainly one of them, frauds involving over 1 million will attract sentences of 2 years or more. However, in some reasonably foreseeable circumstances, and I outlined one above, the 2-year mandatory minimum will be grossly disproportionate. It follows that the mandatory minimum of 2 years set down in Section 381.1 is unconstitutional and should be declared of no force and effect. Conclusion. Like my colleague, I think a sentence of 3 years should have been imposed. However, having regard to all of the circumstances, and in particular the fact that the Crown is not pressing for reincarceration, I agree with my colleague that reincarceration is not in the public interest.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.